Hey, did you know that if you're charged with a crime, the prosecutor is under an affirmative obligation to assist you to prove your own innocence? I know it sounds crazy, but prosecutors in the United States are under an obligation, due process, to only convict the guilty and to ensure the protection of innocent people. Under Brady versus Maryland, a 1963 case from the U.S. Supreme Court, the court held that anything that's favorable to the defense must be turned over, whether it's relevant or material to guilt or punishment. It has to be turned over. We call this exculpatory evidence. And I make wide use of this, trying to get materials that are helpful or beneficial to my client in a DUI case. Today, I had a big major victory in the 35th District Court in Plymouth, Michigan. At issue was whether or not the prosecutor had to turn over XML data. XML data is a tiny little text file that's generated in a computer typically, but in this particular case, generated by the data master breath machine. Every time that there's a breath test failure, an XML file is generated. And every time that a person blows into the machine, an XML file is recorded by the device. And it shows us every time that there's an error, but it also shows us the quality of the breath sample that was provided by the subject. It shows us the volume, the time of the sample, how many times they tried to blow into the device, and how many seconds they blew before the breath test was established to be accepted by the machine. This can lead to suppression. It can lead to the weight of the evidence being considered by the jury as being inadequate. All sorts of great stuff under Brady versus Maryland and under our state's discovery rules. If you're not asking for these XML files in a DUI case, you're missing out on valuable information that might prove you're innocent.